First, we want to thank JLF Seattle for inviting us. We're very thrilled and honored to be here up on the stage with these esteemed panelists. I came to Seattle 30 years ago and was one of the few South Asian lawyers here in town. My wife is born and raised in Seattle, and her parents came to Seattle as immigrants from India 60 years ago, and there was only about 200 families here in the community. And now, fast forward, we have South Asians in all walks of life: lawyers, authors, senators, professors. And so we are thrilled that JLF has come to Seattle and to bring these thought leaders onto the stage throughout the day to talk to our broader community about all the interesting things and ideas that South Asians are talking about and presenting. So thank you, JLF Seattle, for inviting us. I also just wanted to speak for a moment about our connectedness. Mr. Roy, one of the directors here, has talked about how JLF is interested in showing the connections throughout cultures and through societies. And one of the stories I like to tell about our interconnectedness, about in history and as well as today, and it sort of gives us a framework what we're going to talk about here about U.S. courts, Indian courts, constitutions, and so forth. In the 1768-69 time period, there was a famine in Bengal, and at the time, the East India Company had sort of become the overlords of that area of India. They had taken over the Mughals. And there was the famine that resulted in all the looms that were there being shut down. And so the East India Company was losing money exponentially. And they engaged in all kinds of awful behavior to try to get the looms working, but to no avail. And they were on the verge of bankruptcy. So the British royal government realized that the East India Company is too large to fail. They had too many banks in England and Scotland that had East India Company money, and they were worried if all those banks failed that there would be an economic collapse of the British economy. So the royal government decided to purchase or fund 50% of the East India Company with capital. But the royal government needed to get that money from somewhere. And so what they decided to do was increase taxes and monopolize tea. They inserted that tax on tea that was going to the Americas, into Boston. And the colonists in America objected, as you may have known. And in 1772, they had the Boston Tea Party. And so it shows, really meaningful to me, someone who lives in two cultures, both in India and in the US, that we have been interconnected for generations, for centuries. And our forms of government have arisen out of similar experiences. So with that, I want to talk to our panel about some of the similarities and differences between US courts, constitutional theory, and unfortunately Pallavi Wahi, who is a managing partner here in town, was unable to make it, but she has recorded some comments which we will try to get to towards the end of our presentation. So let me begin. Professor Kalantry, what was the spark for you to try to write this book and to get this project going?
Thank you so much, Judge Shah. So I also want to first tell everyone here, thank you, JLF, but I have incredible luck to be with these panelists. Judge Shah is the head of a court that's going to decide a major cases. The Kroger case, for example, his court will decide whether our groceries will go up or not in the antitrust case. One of my colleagues, Professor Siegel, clerked for the U.S. Supreme Court in the Bush v. Gore case. So if you want to know how it is that George Bush became president, you can ask him if he's willing to talk about those secrets. My former colleague here, who I taught with at Chicago, is one of the leading economists. He's an economist and a PhD as well as a lawyer, teaching at the University of Chicago, Pallavi. I am in awe of her. She is Indian, a woman, a brown, speaks with an accent, and heads the major law firm in this city and probably in one of the world's major law firms. So with that, I'll answer your question. I've been a law professor for 20 years, and one thing that always bothered me is, why don't we talk about India? India, largest democracy in the world. India speaks one of the official languages is English. The common law, the British common law, we share that. You were talking about colonialism. Yes, we were also colonized. And yet, when we talk about international law, we talk about Europe. At most, we talk about China or East Asia. So I've been working on India for about a decade and taking students to India and learning the law and teaching the law. And one of my colleagues at Cornell, when I taught there, came up to me and said, he is the founder of empirical legal studies, which is the methodology we use in this book, and said, why is nobody studying India? I studied Taiwan, I studied Israel, let's study the Indian Supreme Court. So we were feeling a real gap. American Legal Academy hasn't thought yet about India, and this is one of the first books that we've spent about a decade. So a decade ago, he approached me, I did a Fulbright in India, and we started this project. Unfortunately, he passed away, but then the second amazing empirical colleague, William, joined us. And I also always work with people within the country. So we have an amazing co-author who's a professor at one of the top universities in Delhi. So it inspired me to learn more about India and bring that knowledge to the US Legal Academy.
Thank you, Professor Kalantry. So Professor Hubbard, as you got involved in this work, what was your draw to this? And maybe you can talk about some of the work that you did and what you've discovered through this process.
Thank you so much. And let me also begin by just echoing the comments from Judge Shah to thank everyone here, and in particular the JLF organizers and sponsors for this wonderful event and this wonderful opportunity. For me, as an American lawyer who has primarily studied courts in the United States, and as an economist, the opportunity to partner with Sital and Aparna on this study of the Supreme Court of India was an amazing opportunity when I realized how little myself and the Legal Academy as a whole really understood about the Supreme Court of India. And what made it doubly surprising was, as Sital mentioned, the common traditions, legal history, tracing back to the English common law traditions, the common language of the law. The official language, of course, of the Indian courts is English as well, which was a great relief to me, who is quite feebly monolingual. In addition to that, there have been countless studies of the United States Supreme Court that are empirical. They're about collecting data on the court, on its decisions, on the backgrounds of the judges, on who the parties were, and crunching the numbers to try to reveal patterns to understand what the court is doing. And we just didn't see that in scholarship on the Supreme Court of India. And what we did in our book was to collect literally millions of cases over decades that had come to the Supreme Court of India, and draw out of that information many new insights on the Supreme Court of India. Now, we're not going to attempt to even summarize the book or present any data to you. What we'd rather do here today is have a conversation about the Supreme Court of India and the United States Supreme Court, and to look at the ways in which the comparison of the two reveals something and maybe offer some lessons from one to the other.
Thank you, Professor Hubbard. So maybe to just give us some structural numbers to work around, Maybe you could explain how many Supreme Court justices are on each court, and roughly about how many cases per year they do. And then I think especially just the appointment process of the differences between the two.
Right, yeah, so I'll just quickly summarize some of the similarities and differences of the two courts that Judge Shah referred to. The United States Supreme Court, as maybe everyone here already knows, has 9 justices who sit on the court. All of the justices sit together to hear every case that the court decides before they issue an opinion. In contrast, if you look at the Supreme Court of India, there are 34 seats, so 34 judges on the Supreme Court of India, and the judges never all sit together to decide a single case. Instead, they sit in groups of 2 or 3 or at most 5 judges to decide a case. Now, the scale of the court. Oh, I'm sorry. I'm sorry. Were you able to hear that okay? All right, so my apologies. Now, the scale of the court is different, not just with respect to the number of justices, but the number of cases they hear as well. The United States Supreme Court will receive maybe more than 6,000 petitions to hear a case each year, but they'll only take maybe 60 of those and decide those cases after a full hearing. In contrast, the Supreme Court of India will receive more than 60,000 petitions for hearing in a given year, and will grant more than or around 14,000 of those. So they'll be taking 14,000 new cases every year, consolidating many of them, and as Sital mentioned, issuing over 1,000 judgments on the merits every year. So that's more than 10 times more than the U.S. Supreme Court handles. I'll mention just a couple other things that are distinctive and interesting when we compare the two courts, which again, in many ways are very similar. They're extremely powerful courts, probably the 2 most powerful courts in the entire world. They are at the apex of their court systems in the 2 largest democracies in the entire world. And they both have immense powers. They have what we lawyers refer to as the power of judicial review. And what we mean by that is what is often referred colloquially in the news as the ability to strike down a law as unconstitutional. And so these powerful courts, a crucial question we want to ask about them is, well, who gets to sit on these courts? Who decides who the justices are? In the United States, the President of the United States will nominate justices to the Supreme Court. And once they're appointed, they serve for life. They're there for as long as they want to be. The system in India is very different. Through a process known as the collegium, the senior-most current justices of the Supreme Court of India will choose who the new justices of the Supreme Court of India will be when there's a vacancy on the court. However, once a justice is appointed, they're not there for life. There's mandatory retirement at age 65. And in fact, that means the terms of the justices are quite short compared to in the United States, because justices tend to be appointed in their mid to late 50s. And so they might serve for only 5 or 7 years before mandatory retirement kicks in, and they leave the bench at that point.
Thank you. And Professor Kalantry, could you discuss how the Supreme Court of India, with its term limits, how that affects its power in Indian society?
So on some metrics, the Indian Supreme Court is the most powerful court in the world. 20% of the world's people are under its jurisdiction, which means it's the court of last resort for those people. And however, over time, I think, particularly in the last few decades, the court's power has arguably gone weaker. Some argue that it is rubber-stamped controversial decisions of the government or strategically delayed decisions. Now, when lay people or non-lawyers or non-empirical scholars think about why that happens, they think about, the judge's ideology, right? In the US, we're so ideological, current Supreme Court. We think they must agree with the government or disagree. But our book is pointing out that that's not necessarily why that happens here, because we're looking at structures and how institutions create institutional policies create weak courts or strong courts, and two of which I will point out why I think they're weaker. So one man has been prime minister for 10 years and counting, but 10 different men, and I say men because we haven't had a female chief justice yet, 10 different men have been chief justices of the Indian Supreme Court over the same time. With this continual churn of chief justices, there is a lack of consistent policy guidance at the Indian court. And the reason for this churn actually is because of the Constitution. As soon as the Chief Justice is getting a foothold, he turns 65 and is required to retire, mandatory retirement age. And this age was created in the Constitution 75 years ago, right, when the life expectancy of Indians was 32. And as our co-sponsors AARP will know, after 65, you can have a really healthy and amazing life. So these judges in India, however, the government is their most largest employer after they leave the bench. They're appointed to these other positions. They have these amazing houses, which carry amazing houses in Delhi, which you don't get if you're not appointed as a judge. And so there's empirical studies that show that they're pandering a little bit to the government when the government is before them. Not necessarily that there's corruption, there's some pandering, and it's a complicated study. So that makes them a little bit weaker, right? And combined with the mandatory retirement age. And actually the third feature, this is their own institutional creation, is, as William said, they appoint themselves. Also very odd in any other court in the world. Yet they're appointing themselves at higher ages. So when one profession is appointing itself, they're thinking, no, you have to have worked at a high court. You have to have had legal experience. So they're appointing them when they're like 60. And so they have 5 years at the court. So a Supreme Court justice on average is justice for 5 years. And so there's institutional stability. So, you know, as a result, I think that these are the ways in which the court institutions has made it unable to be a real check on the executive that one needs in democracies. And so the Chief Justice could make some of these changes. Only the Parliament can amend the Constitution, but the Chief Justice could make the changes. But as you know, but many of them maybe don't have the political will, and in reality, an average Chief Justice now is in office for only 9 months. So the next Chief Justice can just undo whatever the prior one did.
Super fascinating. And we had a conversation just before we came on. And Professor Kalantry, you mentioned how do justices get selected? Could you briefly just describe that? And then we'll turn to Professor Siegel.
Sure. So in 1991, the Supreme Court of India decided that the Constitution reinterpreted to say that they should appoint judges for purposes of judicial independence. So the Chief Justice of India, along with his 4 most senior colleagues, meet largely in secret and decide who they want to nominate. And they make that nomination to the executive, who largely ratifies, as in some controversial cases, the executive might not ratify. We have a chapter on diversity in our book, so I've called this, you know, we know the old boys club, I've called it the old brown boys club, which is true. There have been 6 women out of like 266 judges appointed, but that's a different chapter. But to answer your question,
so very different than the U.S. Supreme Court. And so, Professor Siegel, could you describe first just how, I think most people know, but just very quickly, how U.S. Supreme Court justices are selected, and then secondly, the contrast, as Professor Kalantry has talked about, how their power has diminished in the Indian Supreme Court, but in the U.S. Supreme Court, it's quite different.
Yes. Thank you for the question, and thank you all for having me. Thank you for the festival. It's a real pleasure. They're all essential. They have the expertise on the Indian Supreme Court. I'm the commentator on the U.S. Court, and there are dozens of us in town. So I appreciate the opportunity to be the one up here. Obviously, as most of you know, The president, when a vacancy occurs on the court through death or retirement or theoretically impeachment, the president appoints a candidate, and then the Senate needs to vote to confirm that candidate for the Supreme Court. We can talk about the dynamic of how that plays out currently, or the dynamic of how that's played out historically. Certainly now, as opposed to at some other periods, that makes both the appointment and confirmation process very much steeped in modern politics. The stakes are very high. The justices get younger and younger. The average term goes up and up. So in so many ways, it's like the direct contrast with how things are done for the Indian Supreme Court. The basic narrative of the U.S. Supreme Court, again, very much the opposite, it seems, of the Indian Supreme Court, is one of very intentional, studied, and successful campaign to grow the power of the institution. Certainly there are tools that were there from the beginning, for example, life tenure, that had the seeds of some real power for the Supreme Court. But the U.S. Supreme Court was a weak institution when it was founded. It wasn't clear it had the power of judicial review. There were no other federal appellate judges, so it was a very unpleasant job that involved riding around in horses and carriages all over the country, the process known as riding circuit, to hear appeals in small towns of $100 cases and the like. The leading lawyers in the country didn't want it. It involved pretty soon moving to Washington, which at that time was a nothing backwater wish of a town, right? People didn't want it. People resigned the court quickly, turned down nominations. 5 people were confirmed and didn't refuse the seats, including future President John Quincy Adams. So very limited originally. But pretty quickly, starting with Chief Justice John Marshall, as many of you know, right after, starting in 1801, the justices and the court as an institution intentionally grew its power. Marshall did a variety of things, including famous decisions to establish the authority of the court for judicial review, made the momentous decision that to break with Anglo-American tradition and have the court issue one opinion for the court, as opposed to have each justice speak in turn seriatim. In order to make sure that they all agreed on everything and hammer things out, he made the justices live in the same boarding house. That's one reform that didn't last, but it was important at the time. And then at every kind of crucial stage in American history, when the court needed something to consolidate its power, it kind of went out and got it in the political process. The court got intermediate appellate courts created, got rid of circuit riding. They didn't want to do that. The court several times, most famously in the 1920s, won campaigns to change its jurisdiction or to change the way it selects cases, in particular to get away from all these mandatory appeals in low-stakes cases, so they get to decide their docket, pick what cases they hear, which gives them extraordinary power to focus on what they think are the most important cases. When they felt like they didn't have the trappings of a co-equal branch, they campaigned and got Congress to pass and the people to fund something that's often called a marble palace right across the street from Congress to kind of demonstrate to visitors to Washington the power of the institution, its equality as kind of another branch of government. Substantively, they've consolidated their power to say what the Constitution is. Judicial review, the ability to review the constitutionality of statutes, has a variety of different variations, some of which are more powerful than others. During the 20th century, particularly in the 1950s and 60s, the court articulated the premise that not only do they get to, in particular cases, ignore statutes if they think they violate the Constitution, but that actually the Supreme Court gets to say what the meaning of the Constitution is for the country. Still a controversial proposition today, but very much kind of in the public, consciousness, that's what they think. That what the Supreme Court says the Constitution is what it is. So a lot of work to consolidate power, and the Supreme Court has become a more and more powerful institution throughout American history. Now, over the last half century, there's been kind of an ironic twist here, which is the Supreme Court had worked for almost 200 years in kind of a bipartisan way, the judges and the people who were involved with the court had worked to kind of consolidate the power of the court as an institution, as an independent institution, as an independent branch, as a check on the political branches. But the court has become so powerful, and the public's buy-in to the court's ability to dictate the terms of American society and the American Constitution has become so profound that the political branches couldn't ignore that. And the political branches, increasingly since the 1950s and even more so since 2000 or so, the political branches have become more involved, more committed to campaigning on the kinds of justices they're going to appoint, campaigning on the results they want from the court, paying lots more attention to the political bona fides of the particular people who they're considering for appointment to court, not making any mistakes, appointing younger and younger people, more and more ideological people to the court. Powerful interests have taken to getting more and more financially involved with some of the justices in ways that are intriguing, troubling, and new, frankly. So justices have become more celebrities, and politicians have kind of embraced the popularity of some of the justices on their side. So we're at an interesting point in the history of the US where the court as an institution is about as powerful as it's ever been, but it's much more deeply embroiled in politics and less independent than it may have been 2 generations ago or something. So the future is intriguing as well.
Thank you, Professor Siegel. It is very interesting to see how it began as a check and balance system in 1800s, 1787 when the Constitution was written, and shortly after this time of the tax that people were so upset about, and making sure government was checked. Now we have a very powerful institution in the US, a weaker institution in the Indian courts. Professor Hubbard, how do we see a future here of these political forces affecting both of these courts?
Well, I think one of the things that I feel like I've learned in first studying American courts and more recently studying the Supreme Court of India is the remarkable ways in which political forces are able to work their way into influencing how a Supreme Court behaves, but in very distinctive ways depending upon the structures involved. You have the collegium in the Supreme Court of India, where the Prime Minister, the government has basically no ability, very little ability, to choose who the Supreme Court justices will be. So that the primary tool, the primary means by which in the United States we perceive the president or politics influencing how the court behaves isn't present in that context. And yet, as my co-author Sital pointed out, the fact of mandatory retirement and the fact that justices do not, unlike in the United States, have their pay guaranteed for life. In the U.S., even if a justice were to step down and continues to get paid for being a judge, that's not true in India, which means you have to make a living as a retired Supreme Court judge, and you have to retire at age 65. And it's that financial incentive to make yourself as employable as possible that might lead judges to think differently about how they decide cases. I mention all of this because I think what this points to is it's very easy if one were to just look at India to say, oh, well, the solution must be life tenure, and to just look at the United States and say, oh, life tenure is the problem. The solution is to shorten the terms of the Supreme Court justices. And I think it's what I've learned from this is the complex ways in which politics adjusts to the different rules that affect how a court is formed. And we have to be very mindful of that as we approach the process of critique and reform.
And reform, yeah. I think that's right. As we look forward for reforms in both of these courts, there are lessons to be learned from each and how it can make an impact on the court and the political process. So we have a video real quick of Pallavi Wahi that talks about cultural norms and how as a civil society we can affect the courts. So I'd love to have that video prepared, and then I think we have a moment or two for questions.
Thank you so much for the question, and thank you so much to everyone for having me here. I really appreciate the panel, really appreciate the opportunity to talk with such esteemed speakers, and I apologize for not being able to be there in person. So, the question is interesting because it has within it many nuances regarding just culture and also regarding how we view culture and what we view as real differences or um, more the expectations that we have of each other in different societies. I think in terms of cultural norms, I do think because and I do believe that the ability to have a strong rule of law and a strong jurisprudence means that both court systems are viewed in a similar way. I do think there is a lot of trust in the court systems across India and the US. I do believe people do trust the quality and the professionalism of the judiciary, as well as the professionalism and quality of the legal functions. I think there is a real trust in the fact that both countries are democratic countries which are grounded in the rule of law. So I think those are the similarities. To the extent I think there are differences, I think the big difference culturally that I can see is volume. I just think just being the size of country India is, the volume of the issues and the processes that they have to face just means that it leads to a longer or a larger backlog, which can have an impact on decision timing. But other than that, I would say there are more similarities than differences in a lot of ways, which means that you're able to navigate systems in ways that make more sense. Thank you.
Thank you very much. We're happy to take some questions if anyone has any.
Hi, thank you. It's such an esteemed panel, and it's such a privilege to see you all here. And I also urge all of you to kind of go see a YouTube video when Sital and William's book is released in India, and this panel of who's who of Indian judiciary, when they are really stoked by seeing this data on their face about how the court has been functioning, including the Attorney General of the country. I'm going to take a moment to ask you this question and to continue what you were talking earlier is what's happening in Mexico, where they want the judiciary to be elected by popular vote. And I don't know if you've been following, Pakistan over the last week has been also going in the similar direction. So do you see an emerging markets trend where if Mexico is able to pull this off, because remember, India copies Mexico in a lot of its interventions and public distribution systems and things like that. So if, is there a case if Mexico is able to pull it off, then do you see this as a story of a bad idea whose time has come?
Let me just, before we hear from our panels, let me just interject this fact. So federal courts are unelected, they're appointed. But in state courts, which is where I'm at, we are elected.
Vote for Ketu, please.
Yeah, right. Fortunately, I don't have an opponent, but we are elected every 4 years. And one of the issues about elections is many people don't know anything about judges. And so then they say, how do I vote? And they talk to colleagues and so forth. So there are some pluses and minuses about elections. This accountability, right? You don't have life tenure, and so you have to be accountable to the public, and you have to stand for election. There's some positives about that, but then there's some negatives about people don't know who you are, what you stand for, and our ethics require us to not say anything about cases. We cannot say, oh, I will rule in this way, or I will rule in that way, because that would be unfair to the opposing side. So we have to be very neutral in our statements. But I'd be interested in hearing what the panelists say.
Judge Shah, can I suggest, as we have a lot of people lining
Yes.
up, that you take questions in clusters and then just...
Sure, absolutely.
So the next question, go ahead.
Thank you for a great conversation. I think my question to the authors is, during your research, did you get a glimpse into the power that the spouses hold over the judges? We know what it is. Or is that the second book?
That's an excellent question. Let's just do one more and then we'll answer. Yeah, please.
I'm a little reluctant to ask, but we have here now a candidate for president who wants to break all the laws. Is there anything comparable going on in India?
as a, again, nonpartisan judicial officer, I won't comment on any of the potential law breaking. Yes, please.
The question is a general one to all of you. From a relatively layman standpoint of, look at the laws that's going on in the U.S., specifically the Roe versus Wade that comes to mind. Just trying to understand something which was considered a law of the land for more than 50 years. How is it that the judicial system enables, or how is it it's possible that you could go repeal it? Is it a precedent-setting sort of a judgment, or do we expect to have similar cases that were long on the books but can be turned upside down politically? So just want to get your perspective on it. Thank you.
Thank you.
My question is more comparative. This book, I saw the conclusion, it's about accountability in the courts and how that's needed. So my question specifically for you, Professor Hubbard and Professor Kalantry, what did you learn from this book that could be maybe a cautionary tale for the US courts? We heard some rumblings about things that may give rise to judiciary oversight, term limits, so I'm a little interested in that. What do you think we could learn in the US from your statistical, empirical analysis of India?
Thank you.
So you all covered very well, how to compare and contrast where the Indian Supreme Court is there today versus where the US Supreme Court is. But I'm interested in understanding, it's been about 75 years for the Indian Supreme Court post-independence. I know it was there before independence as well. So how do you compare and contrast where the US Supreme Court was there at that time mark, and what messages or what signals does it give in terms of how the Indian Supreme Court, could potentially evolve in the next 25 to 50 years? Thank you.
Or even 150 years, yeah, right.
Last question.
Yeah. Thanks a lot for highlighting the strengths and the weaknesses of both the US and the Indian court. All of you are experts in this field. If you had to structure a dream court which was balanced as well as had checks, how would you structure it? Is there a court like that anywhere in the world?
Excellent question. Let me turn to Professor Kalantry. Do you want to address some of those questions? And then I'll turn to Professor Siegel and then Professor Hubbard.
Thank you for all those questions, and thank you for that really hard question, Darshana. See, the thing about law professors is we just point out problems. We don't have solutions. So, yes, but I will answer the earlier question of what we can learn from the Indian system. I think one thing that we can learn about the conversation that we're trying to have here about putting term limits on our judges, one thing we can learn is that if you have term limits that are too short, it will create more precedential instability. So someone said Roe v. Wade is overturned. That's shocking and unusual. Our courts here typically follow precedent. But imagine if we had even more churn, we'd have probably 7 times Roe v. Wade would have been overturned. And there's an empirical study that models that out. That's one thing. And I think other thing you can learn is again, the idea of pandering, right? If there could be issues if the retirement age is too early and they retire too early. So I think those are some of the things you could learn. It's hard to know how to create the right court and the right balance. Probably term limits are okay, but not too long. I mean, not too short, rather, some level. And I think what I learned from India is, although I don't like the colloquium that much, the self-appointments process, it is depoliticized. I think our process here wasn't as politicized as it used to be. It's like a litmus test of what the judge is going to do. So I think if we could just get the best judge, the smartest judge, rather than are you pro Roe v. Wade, are you against, and that process, I think, the depoliticization would help us in the U.S.
And you mentioned that you mentioned how the Chief Justices in India have churned so much that there's often a change in decisions after 1 year, after 1 year, after 1 year. We have just a couple minutes left. Professor Siegel, would you like to say anything just about the political impacts of the court and what the Indian Supreme Court can learn from the U.S. Supreme Court from after 75 years?
Yeah, and I want to try to weave that in with a couple of the questions. I mean, it was a great question why it seems like suddenly, maybe it is, maybe it isn't, but it seems suddenly like major decisions that have lasted 50 years, major rights, major structures are being overturned quicker, more willy-nilly, with less hand-wringing. And I mean, I think that flows from kind of the phenomena that I was talking about at the end and that William and I were talking about, which is that the court worked so hard for so long in this country to establish public buy-in to its independence and its ability to interpret the Constitution, that kind of the guardrails came off. And what was keeping the court from doing that kind of thing in the past was a sense, a culture of not going too fast, of adhering to certain kinds of norms, to making sure that the court never deviated too far from the political center for more than a generation, correcting it if it didn't. That had a lot to do with the kind of people that were on the court. It also had a lot to do with the nature of American politics at the time. But it was a big temptation, once the court had consolidated that power, to use the court for more starkly partisan purposes. I mean, the weird thing in the US right now, and it's kind of the flip side of the danger in India right now, is that we don't really have any precedents. This is the first time where the court has a significant, seemingly permanent majority or supermajority that seems in conflict with the long run of the election results for more than a few years, a decade, something like that at a time, and the court doesn't seem interested in going back. So certainly one thing that you worry about as a lesson for all other democracies is disconnecting the court from politics fully. There are dangers being connected to politics, but there are also dangers if the court doesn't feel any loyalty to public values, to the constitutional culture, to how people would like the major questions and the major decisions that they live under resolved.
Thank you, Professor. And we won't be able to answer the question about the role of spouses, but I thought that's an excellent question, and maybe we'll encourage them to write a book about that. We want to thank you very much for your attention and very thoughtful questions.